So we won't have any break right now. We will move on to our first keynote speaker, Professor Jean-François Gerkens.
Thank you very much for this very kind introduction. I'm very pleased to be here, and it's a great honor for me to be in Belgrade to this conference of Iustoria. I've had friendly contacts with people from your faculty for many years, so I thought it was really a good thing that I finally paid you this visit. I'm so happy about it. It's tricky to make names, of course, but there's one former member of the faculty we had a special link with. It was Obrat Stanojevic, of course, as a member of the RIDA, which is the Journal of Roman Law that I'm still actually directing. So Stanojevic entered the scientific board in 1990, and with a bunch of wonderful other scholars. You have the names there, just to name some: Ancrum, Feenstra, Goodme, Casa, Pugliese, Sturm, Viaca, all big names. He was member of the scientific board until his death in 2011. I remember that was Milena Poleazzi who commemorate him at the CEDA in
Oxford.
In Oxford, yes. That was 12.
Sorry, 11.
Yeah.
2011 was he died in November.
Yeah, that's right. So it was 12 in Oxford, yes. Okay, then I was to intervene about the legal transplants of Alan Watson, and I shared a person of him when he was still quite young. Well, in 73, he was maybe a bit older than that, but still quite young. And well, I have to confess that when I was invited to speak about this, well, I hadn't read the book so far, so I had to start from scratch, which was nothing to be proud of. On the contrary, I'm quite ashamed. Certainly after I read the book, because I loved it. So I give that from the beginning. Yes, it has some shortcomings. The ones you said, I mean, that is true. You don't really understand the plan. There are no big conclusions, but still it is really full of insights and interesting things. So because I had to start from zero, and even if the book is only about a bit more than 100 pages, it's impossible to comment on everything he said because it's so rich. So I had to do some cherry picking and take out some topics that I thought I had something interesting to talk about. About the title I announced, that was when I was still reading. So I thought, well, apparently it seems to be directed primarily to the Anglo-Saxon readership, with a lot of law of Scotland, with comparisons with New Zealand, with Massachusetts, with Australia. So I thought, well, maybe there is something to compare with the Western Europe for that. But in the end, it's not anymore that much in this direction that I gave my speech, or that I will give my speech. Well, my plan for today will be threefold. I want to speak first about the Volksgeist. Then I will speak about authority, which comes back in 2 chapters out of 14. And then I will discuss a bit the question of transfer of ownership that he also discusses longer in the book. And in the third part about transfer of ownership, I will divide it in Roman law and in modern solutions, modern law. Now, about the question of Volksgeist, he addresses it in chapter 4 already, in his kind of introduction about legal transplants. And even if Alan Watson does not reject the idea of the existence of a Volksgeist, he gives many examples showing that the similarity between the donor, I don't know what I touched. I don't know if I touched something. I don't think so. Never mind. He gives many examples showing that the similarity between the donor system and the receiving legal system are not necessary to allow a legal transplant, which pleads against similarity and against the need of a similar Volksgeist and somehow. And in his concluding reflections on page 96, he writes, it follows from our reflections that to this point that usually legal rules are not peculiarly devised for the particular society in which they now operate, and also that this is not a matter for great concern. And the page thereafter, speaking broadly though, if one were trying to discover the spirit of people from its law, one should look not at the overall system, but to the details where it diverges from other systems. And I will say it right away, I think that my impression is that Watson is right on that when he dismisses great part of the idea of Volksgeist, even if he does so without a frontal attack. In my view, the idea that the legal system is very much linked with the history and the culture of a people is mainly an idea of the 19th century, when modern states established and felt that establishing a national legal system was a complement to a national flag, a national constitution, and a national anthem. At least this is very much how it happened in Belgium in 1831. Belgium has been invaded and annexed in 1795. So we were French from 1795 until 1815, which means that in 1804, Belgium was French territory and the civil code entered into force in Belgium because it was France. After Napoleon's defeat in Waterloo, we were then merged with the Netherlands, creating the United Kingdom of the Netherlands for 15 years. And during these 15 years, we discussed about writing a common civil code. And there was a lot of discussion between Belgian jurists and Dutch jurists about how to do that. After 15 years, the Belgians were tired of. Belgium decided to separate from the Dutch in 1830, which put on hold, of course, the writing of the Common Civil Code. But it put it on hold only for the Belgians, not for the Dutch. I mean, funny enough, the project of a civil code was already finished in 1830. And it was written by a judge from Liege, so a Belgian, and it became the civil code of the Netherlands in 1838. But for obvious reasons, I mean, for nationalistic reasons, you call it Volksgeist if you wish. Belgium did not want that code because it became the code of the Netherlands. So even though it was written by someone from Liege, so the paradox was that the Netherlands had a Belgian code written by Nicolai, and Belgium went back to the French code written, or not written, by Napoleon's code. It's a weird situation, but this has been lasting for a while. Now, my point is that in 1813, that's what I meant, when Belgium wrote a new constitution, the Constitution of 1831, well, they decided about a national flag, just to identify Belgium. We had a national anthem. We had, everything is a nation needed. And we had this article 139.11. The French codes must be changed as soon as possible, dans les plus courts délais possibles, because we needed, just like a national flag, we needed a national civil code. And that was that belief I was speaking of. And this is why I'm saying that Volksgeist is very much an idea of the 19th century. In writing a new civil code today, we don't think that way anymore. We don't go back to this idea that it's our national pride to have a national code. Okay, then. So Belgium needed a new and Belgian civil code as fast as possible, and well, it has been lasting for a while because actually we're only writing the code now, so it's more than 200 years. So obviously it was not so urgent in the end. At least we were not able to write a new code. The Belgian legislator woke up only in 2014, and we're still not finished, but halfway. Now, it's also interesting because actually Ellen Watson speaks of the Belgian process in not in the legal transplants itself, not in the second edition, but actually he gave a speech in Maastricht in 2000 on the same topic again called legal transplants. And there he spoke more about Belgium. Well, being in Maastricht was so close to Liege anyway, but so this is also why I feel that I was allowed to speak a word about the Belgian situation, also because I think it shows what was meant with the Volksgeist, certainly in the first part of the 19th century. Now, what does all that say about the Volksgeist? I'd say that even though modern countries have legal systems that do not really rely on a separate Volksgeist, there are very often sensibilities relying on some national sentiment. And that is an obstacle to a broader unification of the private law. And yeah, that's also interesting in Alan Watson when he speaks about how easy it could be to write a common civil code for Europe. That was, of course, pre-Brexit time, so it was still inside of Europe. And he thought it would be easy, and somehow that is also an explanation at one point why Belgium didn't write a civil code, because they thought, well, Europe is going to do it for us, so we don't need to bother. But that shows also the evolution. At some point, the Volksgeist said, well, at least in some countries like Belgium, we're happy with the European code. But there has been resistance because, of course, well, you know that we don't have such a common civil code. Actually, they have been trying to write one, and then they said, well, let's do only law of obligations. And when that didn't work, they said, well, let's try at least the contract of sale. And this didn't work either. It became just impossible to do it. So maybe that's the lower key Volksgeist Alan Watson is talking about in his book. That Volksgeist shouldn't be important, but it creates resistance when you try to go further and unify the things. So that was my first point. The second point is about the question of authority in legal transplants. And Watson discusses the question of authority by reminding that in ancient legal systems, the set of rules was often a gift of God, like the 10 Commandments given by Yahweh immediately to Moses. Then the authority could also come from national heroes. And he doesn't make the name, but I would say that Napoleon could be considered one for the French. It is, of course, true that the resistance of a strong authority helps the code to come into force, as it is less discussable, and you cannot discuss with God anyway. Who can argue with God, or even with Napoleon, with any dictator? If it's a dictator dictating the code, well, you must accept it. There's not been much discussion for the Civil Code of Italy in 1942 either. Now, as Watson puts it, legal transplants also happen without such an authority. And he gives the example of the influence of Roman law on Scottish law. In his Institutions of the Laws of Scotland, Stair cites the Roman sources directly, but does not consider Roman law binding for its authority, yet being, as a rule, followed for its equity. This is, of course, makes us think of the famous position in Western Europe. Within the Holy Roman Empire of the Germanic nations, the emperor opted for Roman law. This choice created the stress among the jurists of the principalities and other states integrated into the empire. If Roman law was the emperor's law, then it had to be distinguished from it and set aside within the principality. From then on, when the Roman rule was nevertheless accepted at local level, it was by virtue of the justification non ratione imperi sed imperio rationis. It is the quality of Roman law that makes it necessary, not the authority of the emperor. The same idea has been applied a bit everywhere, also in the Principality of Liege, where the Principality of Liege was within the Holy Roman Empire of the German nations. At some point, customary law of Frankish origin in Liege has been replaced very quickly by a Roman law, and we are in modern times, so we're in the 16th, 17th century. And I'd like to give you just an example. I have a PhD student working on it. Her name is Marie-Sophie Sillan. She's almost finished. And she's been doing a lot of archive work just to figure out what law was applied in Liege and how that changed. And it's really interesting. So her PhD is on the legal position of women in the Principality of Liege in modern times. And she found an interesting evolution about the patria potestas. You're all acquainted with patria potestas, of course. So actually, in Liege has been a reintroduction of the patria potestas. In French translation, puissance paternelle. And it came instead of what was called Montbourny, and that was the Frankish customary system. So the terminology has changed completely. And it was going back to Roman law terminology with also all the Roman rules. I mean, the age for marriage was 12 for girls, 14 for boys. Legal capacity was 14 when the boy had no ancestor alive. And actually the majority was 25 years, just really the same system with the tutor, and the name changed. So they came back to tutor, to curateur. I mean, it was plain Roman law. And what is also funny, when you discuss with legal historians, they would tell you, well, this is not Roman law. This is our law. We accepted it, but it's absolutely not Roman. And when you try to figure out why it's not Roman, they tell you, well, the patria potestas was completely different because the father was allowed to kill his kids. Then you would you point out that, well, that was at the very beginning in archaic Roman law. Very early, that was considered a crime to kill your own children. So, but you find that very often a resistance against the authority of Roman law, because even today with legal historians, you find that everywhere. And actually, that's what the PhD is about. With the introduction of Roman law, legal historians say, well, that from that moment on, the legal situation of women got worse in Liege. And well, so far, the work of my PhD shows the contrary. that actually the situation got better, because widows had a full capacity. I mean, they had no tutor once the husband died or disappeared for some reason. And so we have a lot of women who were powerful and rich in the Principality of Liege. And also thanks to the reintroduction of Roman law. Now, now my conclusion here is that in the Principality of Liege too, Roman law found its way back through its own qualities. It was the law that lawyers and judges would learn at the university. It was there. I mean, the judges and the lawyers would go to university and learn Roman law. So it was so much more sensible, so much easier to apply the law they learned instead of that complicated customary law. In the end, yeah, Roman law prevailed. Now, more recently, with the new so the plan of the Belgian Civil Code is a plan in 10 books with general, well, a general part in the beginning. It was supposed to be a allgemeiner Teil like in the BGB, but that ended badly. We only have like 10 articles. Then you have persons, you have goods, successions, obligations, liability, special contracts, proof or evidence, securities and prescription, 10 books. I told you that we're halfway. So in red, you have the books that are already in force. And part of book 2 and 4 are also already in force, but I let them in black because they're not finished. But half of it is in force. Coming up, we have book 6 on responsibility. It has been voted by the parliament, but is not in force. We don't know when it will be. I suspect it will be on the 1st of January 25. Now, why am I talking about this? Well, for the same reason of authority. So after more than 2 centuries, we have a new civil code, and for a reason that remains unexplained, there are more definitions in the new civil code. Well, we have a lot of definitions. I mean, the Napoleon Code had definitions, but we have more. Like one that has been added is the first article of book 5, the definition of the obligation. L'obligation est un lien de droit en vertu duquel un créancier peut exiger, si nécessaire en justice, d'un débiteur l'exécution d'une prestation. Now, don't know if you understand French, but if you do, you will recognize very easily that this is an immediate translation of the Institutes of Justinian, book 3, paragraph 13, Principio. Obligatus juris vinculum, l'obligation est un lien de droit. It's exactly that. So Roman law has come back also in the new civil code. So you could think, wow, we have a very knowledgeable legislator. They're good, they know Roman law. So I was quite proud. And then I happened to know very well the professor, the colleague who wrote most of book 5. And he happens to have been an assistant with the same professor as me of Roman law in Liege. So I was sure it was because he remembered Roman law. And well, the answer is a bit disappointing because it did not remember. He just wrote that definition thinking it was a classical definition, not knowing that actually it was Roman law. And now, you can see the glass half full or half empty. You can see it half empty saying, well, even people who have been close to Roman law tend to forget very much of it. So it must be worse with the students. They must forget everything about it. The half full glass is that, well, again, Roman law is prevailing on its own forces. And it is certainly surprising. Now, I gave you this definition, but we have more, because 5.2 is the natural obligation. We have no such definition in the Code Napoleon. 5.3 is just the different sources of obligations. There was nothing of the like in the Code Napoleon. So we entered a lot of Roman law in many places. I mean, in the books we have already, there is a lot of Roman law. And the legislator doesn't know. Because, I mean, I've been reading the documents of the parliament. No, they compare with the Netherlands, with France, with Quebec, occasionally with Germany, but almost never. But there's never been any word of Roman law anywhere, and there's so much Roman law in it. What is also very funny is that the Article 5.1 is actually really very close to the translation that Roger Vigneron gives to his students about the text of the Institute. So the wording is the same. I didn't find any other translation in French of this passage of the Institutes that was so close to our Article 5.1. So, well, the source is in the end obvious. It was the course of Roman law in Liege. But it took someone to see it. Now, I'm coming to my third and last point. It will be a bit longer than the two first points. The question of transfer of ownership and of risk. So that's chapter 14 in the book of Alan Watson. I must say that the reconstruction proposed by Alan Watson is really well done in such a limited number of pages. It's 5.5 pages. To summarize it even more, Alan Watson shows how the system of transfer of ownership and risk in sale finished by becoming different from Roman law, but also from each other in legal systems that derive from Roman law, though. In Roman law, the transfer of risks and ownership happens separately. The risk is immediately transferred by the consent on the contract of sale, whereas the ownership is transferred only with the traditio or with the mancipatio. In French and German law, both transfers happen at the same time. The difference being that in French, these transfers happen already at the moment of the consent on the contract of sale, and in German law, these transfers come with the dingliche Einigung. Let's call it the German traditio. And then there is the Swiss law, Alan Watson also speaks about, which follows the Roman pattern. The buyer bears the risk even if the thing is still in the hands and the ownership of the seller. Now, on this, I have a few comments. Of course, it is so short that he couldn't speak of everything, but it is true that there is room for some improvement on that point, I would say. Or at least, I mean, scholarship has evolved. I mean, Roman lawyers have been writing on this. They seem to be very keen on this topic, so they never really stopped writing about it. Just to summarize it, what the problem of the risk in the contract of sale is, I'm sorry if that's very evident and easy, but the problem, of course, arises when delivery to the buyer is foreseen at the moment after the perfection of the contract of sale. Because if between those two moments the thing perishes, well, the obligation to deliver the thing becomes impossible, whereas on the other hand, the obligation to pay the price remains possible because of this so-called general non periunt rules. So you have this stress between an obligation that is still possible and one that is not possible, and you have to decide. You have to decide whether the obligation that is still possible will be fulfilled or not, or must be fulfilled or not. So you have to decide whether the risk falls on the buyer or on the seller. Basically, you have two options. Periculum est emptoris, the buyer must pay the price, of a thing that he will never receive, or periculum est venditores, the seller will never receive the price, or will have to pay it back. And I mean, there is even a third possibility that Alan Watson also speaks indirectly about. It's an eventual mixed solution, and that's only a footnote referring to Dauber, about the fact that he says, well, Dauber says, but Watson says too, I believe, that no legal system has ever tried a mixed solution where the loss would lie both on the seller and the buyer, so would be divided. But theoretically, it is possible. But I'll come back to that. Now, there is an agreement that, I mean, amongst Roman lawyers, that the main rule is periculum emptoris ante traditionem, before the traditio, the periculum lies on the buyer. And that's also the starting point of Alan Watson, who quotes a text from Paul. I'm not reading it completely because it would bring us to, it would be too long. But, well, in this text, clearly Paul writes that the risk is on the purchaser, on the buyer. Now, a minority of authors disagree on this and consider that the risk was borne by the seller in Roman law, and that the rule was periculum est venditores. Of course, when you read Paul, you wonder how anyone can say that. But there are texts that are, well, at least interesting to compare. And on the next one, I will be a bit longer. It's well known of the edile that destroyed beds, which had been bought and which were left in the street. If they had been delivered to the purchaser, or if it was his fault that they had not been delivered, it is clear that the risk is on the purchaser. Well, so if the traditio had already found place, of course, then the buyer, the purchaser, was the owner. So he loses the beds as the owner. If he was in mora creditoris, which is meant by it was his fault that they had not been delivered. Well, in mora creditoris, the same rule. I mean, of course, you were late in taking the bed, so it's your bed. B-A-D, not B-E-D. Now, if I go to the last part, but if the beds had not been delivered, so we are ante traditionem, and it was not due to the purchaser that the delivery had not taken place, the risk will be on the seller. And literally, Paul writes, periculum est venditores. And we are in the obvious case when, I mean, the beds are sold, the contract of sale exists, and there has been no traditio. So here Paul is stating the opposite, the same Paul. So then we can understand that there is a reason for some doubt. Now, how can we figure an explanation for that? It's been some years now that I accepted Mario Talamanca's explanation that, but this is just the same. This is the Latin text. Quod sineque traditi essent neque emptor in mora fuesit quo minus traderetur, tradentur venditoris periculum erit. Very clear. But I said I followed Mario Talamanca's explanation. I think it's insightful. Now, of course, that he has to invent a little because we don't have all the necessary information, but I like the invention. Now, is it true or not? I don't know. So he starts with the point that actually Paul is commenting Alfenus Varus. So in his idea, of course, this case is from the late Republic, and in times of Alfenus Varus, you have a sale of beds that turn bad because an edile comes by and destroys them because they're probably on the street and cars cannot pass. Now, in the eyes of Talamanca, the solution periculum venditores is the solution of Alfenus Varus. So he says, actually, during the Republic, the main rule was periculum venditores. It is the seller who bears the risk. And that changed afterwards. And how did it change? Well, it changed first because of the slave market, saying that actually, and that was Labeo who brought that exception to periculum venditores, saying that on slave markets, well, it's difficult for the seller because anything can happen at any time. So on slave markets, the risk would be on the buyer for the first time. So that would have been the exception, bringing then a controversy between Sabinians and Proculians about periculum venditores and emptores. The Sabinians going for periculum venditores and the Proculians for periculum emptores. And in the end, the Proculians prevailed. And this is the situation we have in the other text of Paul. And this is, of course, also the situation still in Justinian's time. And he says, actually, the evolution from periculum venditores to periculum emptores has been very much helped by the generalization of the custodia. I recall that the custodia was for the seller an obligation to preserve the thing that he sold until the delivery to the buyer. So he had to guarantee that the buyer would receive the thing. And in this guarantee, he had also to bear the risk for casus fortuitus, as long as it was in the sphere of control. So such as a theft by a thief. So, actually, this made the situation less difficult for the buyer because part of the risk was still taken by the seller through the custodia. So Talamanca again speculates that the initial periculum venditores could be explained by the fact that initially buying and selling constituted an exchange of a thing for a price, and that the payment of the price would only be justified in exchange for a thing. Then the evolution would occur with the special sale of slaves, as I told you. So this was, in a few minutes, just a summary of, for me, the very seductive reduction proposed by Mario Talamanca. Of course, the doctrine did not stop the great Roman author. Other authors have pointed out since that while this construction was attractive, it was also based on a great deal of conjecture. And just to name one, Martin Pennitz has me too. That's actually the cover of my yeah, it's a good one again. Oh, there's a network connection issue. It says, I don't know whether it disappeared, but
I'll check.
Now, so there are still other options and other explanations. For Martin Pennitz, it's all a matter of formula process. So he writes that the word periculum must be taken in the sense of the risk within the trial. For Pennitz, the synallagmatic character of the contract is secondary to the effect of the actionis empty and venditi. These actions are actions in good faith, which implies that they have some limits. So if we take the rather simple case of a sale of a slave that dies naturally before the traditio, the risk falls on because he will be granted the actio empty only if he paid the price. But this action will not allow him to obtain the traditio of the slave from the seller because the latter did not commit any culpa or dolus. So I'm not going into details about Martin Pennett's solution, which is also of great interest and completely different. Now, I think that, well, I come back to Alan Watson and Roman law at the end, in the conclusion. I'm moving to law of periculum re venditae, focusing on the three same legal system as Alan Watson, adding Quebec law. You will understand why. Alan Watson shows clearly the evolution from Roman to the different French and German law, calling the German approach more logical. And I fully agree to that in modern law. As the transfer of risk, it is logical that the buyer will bear the risk starting from the moment when he actually possesses the thing he bought. So, I mean, it's logical that the risk is with the owner and the one who actually possesses also the thing. So I agree with Alan Watson when he says it's more logical. But can we consider the differences between French and German law as expressions of different Volksgeist? Maybe partially. Partially, it's a matter of chance. Just to go through quickly. Well, that's the French version. In French law, they have the rule res perit domino. The owner bears the risk, but the owner being, of course, the buyer. In German law, you have something that is means almost the same. Casum sentit dominus. The risk is borne by the owner, but it's just another maxim. Means the same. The difference between German and French law is, of course, that the owner is not the same person, and that the owner is the seller in the German law case. Now, yeah, an important difference coming from the existence of a dingliche Einigung that I call the German Traditio, that French law does not have anymore. And Alan Watson explains that very well, but I think I don't have time to go back to that now. I'm actually about to finish. So you can say that you have two main options. Either you use the French system, like in Italy, Belgium, and Spain, and you say, well, periculum emptoris, because the buyer bears the risk being the owner of the thing since the beginning, since the consent on the contract of sale. Or you have the casum sentit dominus, I mean, the German rule, followed by Austria, the Netherlands, Greek law, with the periculum venditoris. It's the seller who bears the risk because he's still the owner. So that looks quite easy, but you see that in all these legal systems, the thing is that the risk is borne by who is the owner of the thing. It is not the same in Swiss law, because there they have, well, as Alan Watson puts it, actually the Roman law system with periculum est emptoris, the buyer being not being the owner. So the risk and the ownership are not transferred together. So how did that happen? Actually, Alan Watson puts it just like it was Roman law, but I spoke with Swiss colleagues who explained that actually it was a negotiation while they were writing the code. Because amongst the jurists who wrote the Swiss code, of course, you had French-speaking jurists and more German-speaking jurists. So the German speaking jurists being the majority, they insisted to have the German way, so that the ownership would pass over only with the Dingliche Einigung. So only when there would be a physical handing over of the thing. And then the French jurists said, okay, then we'll do it your way for the ownership, but for the risk, we want our system. And this is how the French system has been implemented in Switzerland, just as a bargaining between the two options in the contract of sale. And this is why, in the end, in Switzerland, they have periculum emptoris, because the risk is transferred immediately, the ownership only later. But it has nothing to do with Roman law. It is just, yes, but it is by chance. And then again, you wonder, well, it is certainly not the Roman law authority, incredibly. And is that Volksgeist? Well, if you have a blended country, eventually you have a blended Volksgeist. But does that still mean anything? I don't know. Never mind. But the funny thing is that, well, Alan Watson stops there, but actually there's very logically a fourth option. You can have it the other way around. Because in Switzerland, you have the risk immediately in the ownership afterwards, but you could have also immediately the ownership and the risk afterwards. And that's actually the situation in Quebec, and this is why I mentioned it. Well, this is just Swiss law, but I will not be too long about it. I just read eventually the two articles of the Civil Code of Quebec in English translation. Contract creates obligations and in certain cases modifies or extinguishes them. In some cases, it also has the effect of creating, transferring, modifying, or extinguishing real rights, which is the case of the contract of sale. So the contract of sale in Quebec law transfers automatically the ownership, just like in French law. And then the debtor of the obligation to deliver to the property continues, however, to bear the risk attached to the property until it's delivered. So you see that even if the buyer is already the owner, he will not bear the risk until he receives the thing. So that would be the logical fourth possibility. So concluding, you have four options. Either you have periculum emptoris or venditoris, and within these two options, you can decide whether you will transfer risk and ownership together or separately. And all systems exist. I mentioned only a few, but you can add actually Louisiana next to Quebec. And that's actually why I'm surprised that Alan Watson didn't mention it. You have also Arabic codes like the Egyptian Civil Code also has the system of Quebec and Louisiana. Now, even though Alan Watson said that he thought that the German system was more logical, well, there's an explanation why the solutions are so split, why everything feels differently about it. In my view, the problem comes from the fact that the situation is not just, it's unfair for someone. This loss of the thing that has been sold between the moment of the consent and between the moment of the handing over of it. Well, it has to be unfair for someone. And well, you have to decide for whom it will be unfair. And there is no good solution to that. Unless, as Dauber offered us, thought we might try, and split the loss and say, well, buyer and I mean, the buyer will pay half the price, for example. But again, that has not been decided. Now, yet there is one legal system in which there has been some kind of mixing up of those systems. And I mentioned it earlier already. That's the Roman law system. Because, as I said, the changing from periculum venditoris to periculum emptores has been helped by the custodia. And actually, the risk is divided in two in classical Roman law. Because if it's casus fortuitus, it will be borne by the seller. And if it's vis maior, it will be borne by the buyer. So the only legal system I know that somehow divided the risk, not the loss, only the risk. I'm saying, well, in this case, it will be the buyer. The other case, it will be the seller. For me, that's classical Roman law. So, Alan Watson's book is brilliant in my eyes. It was very inspiring and full of interesting insights. And it was absolutely a very good idea to organize this conference on the occasion of the 50th anniversary of the book. Thank you again for inviting me and having the occasion to speak about it. And thank you for your attention. Picture of Liege just to finish. Thank you.
Thank you very much, Professor. And now we have some time for questions. Are there any questions?
Can start because there are so many interesting things we heard. In fact, maybe I will have some comments on every of these. First, Volksgeist. This what we heard about the Belgian law. It resembles me very much on Serbian case because we now we had this Serbian Civil Code in 1844, which was of course transplant from Austrian law, but there are some elements of Volksgeist as well. For example, Institute of Zadruga, big family unit, and this is a very complicated question about that. On the other hand, now we don't have a civil codification anymore. Also in Yugoslavia, there was no civil codification, but now we have a draft of civil codification because it was meant to do something all embraced all parts. For example, we can codified law of obligations, the same as now it is in Belgium, but we don't have whole civil code, and we have now draft. But that draft suffered severe criticism because it doesn't have all one spirit, because different lawyers were in charge of different parts, and in some parts you have a very strong influence of German, for example, code, and in the law of obligations that we adopted, there is much more of Swiss and French influence because the big professor of ours, Konstantinovich Mikhailov, was influenced by that part of law, and of course our old civil code was influenced. It was in fact transplant of Austrian code. So this idea, you said that codification is now it is and Volksgeist is idea of 19th century. It's in a way true, I think, and it is very difficult to apply it now and to have national civil code as immense of national geist of I think this is one of my.
Can I react to that? Because yeah, it's very interesting. Absolutely. We have transplant, and that's very obvious. Now, I mean, we take ideas a bit everywhere. A modern legislator who would draft a code now, it would be difficult for him not to have a look at other systems and compare. But that's also what Alan Watson says. I mean, we've been taking ideas and rules everywhere all the time. And that's absolutely obvious. Declaring the contrary would be stupid. Actually, that was his speech in Maastricht in 2000, when he was actually asked to react to the criticism of Pierre Legrand, who was very harsh on this book. But he gave his speech. I have the speech there. It's really interesting, and I'm completely convinced by Alan Watson. I mean, without that, we take ideas and rules everywhere all the time. And well, if Belgium is now able to write the civil code, it's mainly because they are not admitting that they are taking ideas from elsewhere. Actually, we have the same problem with 10 books, and we have 11 commissions working separately. So in some books, you will have a lot of definitions, and they will add definitions, others will not care adding definitions. So it will be not unified in a way. I mean, in the style, it will not be unified. It is already not. But what, I mean, we don't hear many people complaining about it, mainly because they declare that they would not change the law. Actually, they would just rewrite the law that we are applying already. Just write it in a more modern fashion after 2 centuries. That makes some sense.
Another thing I would like, sorry if I hope that other students and will have questions, of course, but just I want to, I noticed one thing, because we are making the civil code and you have definition, for example, many definitions, but I think it is always very complicated with the definition of extra responsibility, extra contractual responsibility, this part with delicts and quasi-delicts, because I was reading something about that from French civil code. There are so many difficulties with this part of codification, because
but it's written now, so
now
in Belgium it's finished. The book 6 is not in force, but it is finished. Yeah, we moved from 6 articles in the Napoleon Code to 50 something. So
this extra contractual, because
it's book 6, yeah.
I didn't see it on your plan of what was codified and what is not. Maybe
okay.
Is it any definition of this there? Or
I confess I haven't read it because it's not in force. So it has been voted, but I didn't have time to go through it. But I know that, well, if you multiply the number of articles by 10, then there are many more rules. I know that they implemented rules about causation that were not present before. But yeah, it's only been voted like a few weeks ago, and so I didn't read it. Actually, it was supposed to be part of book 5 with obligations first, and then they decided to separate it to add a book. So we went from 9 to 10 books, but I didn't mention it because I didn't think it was sufficiently interesting.
Thank you, first of all, Professor Gerkens, for this wonderful lecture. And my question is a short one, because we've seen the four different ways of how risks is treated in different legal systems. And is it periculum emptoris or periculum venditoris? And we kind of understood the two major systems of solutions, the French one and the German one, and the Swiss compromise. But what is the source of this norm in Quebecois, in law Quebecois, in the law of Quebec and the law of Louisiana, since the logic would state that it would be similar to French system, but it's the complete opposite. Thank you.
Yeah, well, actually, it's not the complete opposite, but it is logic. It's the logic of Alan Watson, actually. When Watson says the German system is more logic, it's like Quebec followed Alan Watson, because Alan Watson says it's not logic that the buyer bears a risk when he doesn't have the thing. And so that's what he doesn't like about French law. And that's what in Quebec they didn't like about the French law. I mean, it's okay to be the owner immediately, like the French. That's what the Quebec said. So we follow the French on that, but it's not okay to bear the risk immediately. So somehow in Quebec, they followed the logic of Alan Watson saying, well, at least for the risk, that will be transferred later. So there is, to my knowledge, no other explanation to that. It's the same explanation in Egypt, where there has been a strong influence also in writing the code. I mean, the first code was written by French, but they also thought, okay, it's okay to have the transfer of ownership immediately, but not the risk. It's not normal. We should wait until the buyer has the thing. So that would be my answer.
Are there any more questions? Go ahead. Oh, thank you for letting me know. So, Nicola, go ahead.
Thank you very much, Professor. This was really a wonderful lecture. I really want to thank you for this. And I was deeply intrigued by the notion of a civil code being a symbol of the nation state. And my question refers to really the Volksgeist as well, like Professor Poloyets. And I really wanted to ask you the following.
I didn't hear the last sentence, sorry.
So my question is the following. Is the goal of a civil code as this symbol to literally maintain national identity? Is this an aspect of the Volksgeist as well? To maintain national identity while adopting some, let's say, foreign legal solutions? Thank you.
Well, as I tried to explain it, Belgium had this need to exist at the very beginning because nobody believed that Belgium could be a state, that they could live on their own. This is why they first were merged with the Netherlands. So we had to prove to the world that we were actually a worthy nation. So everything that would come across as a good sign in that direction was fine. And the codes were certainly something of the kind. I mean, you had that everywhere in this period. In the 19th century, before the unification of Italy, you had codes in every area. You had Piemonte, you had Modena, you had the Duchy of Parma, you had the Kingdom of the Two Sicilies. I mean, they all had their own codes. And that seemed to be just necessary for a modern nation. So Belgium wanted to be a modern nation with a modern constitution. We were imposed a king because we could not be a republic. England would not allow that. So, I mean, it was about all that. Now, as I explained afterwards, there have been projects in Belgium to draft a new code. Basically, I think in the 19th century, when we had the project of François Laurent, that was still in the idea that we had the need for a national code. But François Laurent was far too progressive. He was giving too many rights to women, so the Catholic Party didn't like it. And so the problem for him is that he was liberal, and well, the project should have entered into force. It was the Catholic Party at the government for a long period, so they buried the project of François Laurent. After that, we didn't have any decent project, nothing really, until 2014, when it became obvious that there would be no civil code of the European Union. But that also speaks about Volksgeist in Belgium. I mean, we didn't consider that we needed a Belgian code anymore. If there would be a European code, that would be fine for us. So this is probably the most, the strongest negation of Volksgeist, when you say, well, yeah, we're happy with what you will offer us. Now, the fact that we still wrote we are still writing a code now is because it didn't happen, and well, there was some need for modernity. That's basically it. I don't know if that answers your question.
It does, Professor. Thank you very much.
Any more questions? Yes, yes, go ahead.
Oh, it was on.
Sorry. In fact, now it is about authority of Roman law. This is another point you were talking about, and you mentioned this, the definition of obligation, and the author did not know that it is from, in fact, a Roman Justinian definition of obligations. I had a similar experience when I was reading again about quasi, in fact, this part of law of delicts and quasi delicts. In fact, it is not called like that, but reparation of damage out of contract. And in the books in the comments, although you can really recognize casuistic provisions of Ephusis Valdeii Actis and other Roman quasi-delicts, in the commentaries, it is never mentioned anything about that, neither that it derives from Roman law or whether something like that. It was also very surprising for me.
Yeah, the ignorance is sometimes surprising when you don't expect it.
So if there aren't any more questions, I would like to thank Professor Gerkens once again for this wonderful lecture. We shall now take a 15-minute break. There should be coffee and some sweets outside, and after that we come back here for our first session where Professor Poloyets will be chairing.